Join us live every Tuesday from 4 p.m. to 5 p.m. Eastern Time on GluFM for Mind in Your Business with me, Attorney Rishma Eckert, to discuss the law and your business. Email us with your questions at info@mybshow.com. And remember, success comes from Mind in Your Business. Welcome to another episode of Mind in Your Business. I am your host, Rishma Eckert. I am an attorney at Eckert Law, PLLC, where we practice business law, international law, definitely corporate law. And today, like I said before, we're talking about international contracts. For those of you who do not know, I do have an LLM, which is a Master's of Law degree in comparative and comparative law and international law from Stetson University. So when I say this is one of my very favorite types of law to do, I really mean it because I actually have a master's in it as well. One of the reasons that I wanted to cover this topic specifically today is because it's sort of a follow-up from our last week's episode where we spoke with the Guyanese American Chamber of Commerce, and they talked a lot about trade. They talked a lot about international contracting, doing business between Guyana and the US or Guyana and other countries. And so this was very topical for me, and I figured, well, let's go ahead with the international route because I haven't really talked about international contracting before. And so as I was speaking with the GACC, I thought I had that idea of, well, let's just continue down this road and make this sort of like an international theme that we're going with right now. A little bit of notes before we get into the topic today. Remember that the Paycheck Protection Program is ending at the end of this month. So if you need to apply, if you need additional funding for your business, please go to the SBA.gov website and look at your eligibility. The forms are there. All the information that you need to apply is there. So please take advantage of it if you really do need it and you're eligible. Annual reports for all Florida businesses were due May 1st. So if you missed that deadline, I'm sorry to tell you, you're going to have to pay a $400 late fee, but better late than never. Make sure that you pay because come September, I believe it's somewhere around the mid-September or probably the third week in September. If you have not yet paid, the state will administratively dissolve your company. So please make sure that you file your annual reports. Small business spotlights. So what we try to do in this program is spotlight your business, highlight your business so that you can have visibility for your goods and services. And as Lisa mentioned, this program is sort of everywhere: Florida, UK, Canada, Asia, Africa, Jamaica, New York, and Kentucky within the US. So if you would like to have an opportunity to highlight your business and be interviewed by me so we can talk about how you got started with the business and sort of you as an entrepreneur and highlight your goods and services, please go ahead and email us at info@mybshow.com and we'll try to get you into one of our small business spotlight slots. Ask MYB. So also, if you have a topic that you would like for me to cover, please go ahead and email us at info@mybshow.com. A lot of times I will turn that into a show because, we're here to make sure that we can provide resources to our listeners, and you can help us by letting us know what it is that you would like for us to cover, whether it's a new topic or expounding on something that we've already done. My quote of the week, and I absolutely love this quote, it's by Anita Roddick, and she says, "Communication is the key for any global business." Communication is the key for any global business. I'd like to say communication is the key for any business, but especially global businesses, because now, and I'll get into it, you're talking about really, really different countries and different systems, different everything. So you have to make sure that your communication is on point for how you're going to go ahead and do business. And as lawyers, how do we communicate? Through contracts. We have to make sure that everything is spelled out into that contract. So today I would like to talk a little bit about considerations for your international contract. And I would also like to talk about, more highlighted issues. That we talk about contracts a lot on the show, but I want to point out a few clauses that have to be even more scrutinized and highlighted, especially in the international contract world. So let's get started. I find this very interesting, so excuse my enthusiasm. I get very, very excited talking about stuff like this. So bear with me, and I hope you get something out of the show today, especially if you are selling to other people around the world, whether it's your goods or services, or you're doing business with someone else other than the country that you're in. So why do we need to even have international contracts? I mean, you're figuring, well, I have my business, I'm rocking and rolling, I'm doing really well, I have my set of contracts. Why do I even need to consider having these international contracts? One of the main reasons is, other than stating the obvious, you're in two different countries, is that you have different legal systems and different laws that apply depending on what jurisdictions you're in. So you have to be aware of that. If you are in the US and you're selling to someone in a civil law country, like, Latin America, they have a completely different legal system than the common law system, which the US is based on. And a lot of the other Commonwealth countries and a lot of the British Caribbean countries were based on a common law legal system. So if you're contracting now with someone who is in a completely different legal system, you have to be able to put in your contract something that sort of bridges that gap so that you can both be on the same page, because you're working under one assumption, they're working under another assumption. And, communication is the key here. We have to make sure that everyone understands the transaction that you're doing. Again, language, right? So we're talking about contract language. A lot of people tell me, oh, legalese. I can't stand legalese. I don't understand it. Can you imagine when you're dealing with other languages now? So it's really important that words have power, words have meaning, that you're able to put into your contract something that both of you have the same exact understanding about, right? So, it could be something really, really simple that you're thinking, well, of course it means that thing. But for another person in another country who speaks another language, it might not mean that. So, here's where we get to the real nitty gritty. You have to make sure that you're both on the same page with that contracting. So that's kind of like how it's different too from whether you're just contracting within the US. If you're doing Florida to New York, I mean, yeah, there is differences within the states, but you're still within the US. So, you can sort of maybe work under some of the same assumptions, and you can go to court and prove that this thing means this thing. If you're talking about, Latin America to the US, or Asia, to the US, we're talking about totally different cultures, totally different understandings, which leads me to my other point. Culture and those standards of doing business. Now, completely different again in the way of doing business. You always hear about the Asian cultures. They're very stern but polite, and certain things you have to learn when you're meeting, and even when you're negotiating, there's very distinct do's and don'ts of those cultures. And they always bring up the Japanese cultures and stuff because they are very, like, their way of doing business is very different from other countries. The US is very direct. This is my opinion. The US is very direct in the way that we can say, I want that, and that, change this, add that, remove that, whatever. And I've found that doesn't necessarily translate well to when you're doing business in other countries. And specifically, like, we've done some business in Belize, and I've represented clients in different Caribbean countries. And again, it's like, they want a more smooth transition into, this is what we would like to have, let's really negotiate. And for me in the US, it's just like, you're down to business and you just say your points. Again, culture plays a huge role. And without necessarily adhering to those cultural tactics, we can make sure that we have in your contract what you both will agree on. So, there's a negotiation, then there's a contracting part, but you have to make sure that you agree. So where does this apply? What am I even talking about, right? So if you're having a contract for a sale of goods or services in a different country, if you're having contracts, for example, distribution, right? So you might have a product, but you want to distribute in Jamaica, or you might want to have a distribution center in Belize, and I always pick Belize and Jamaica because I'm Belizean and Lisa's Jamaican. So we always pick those. If you want to have, for example, you have a vendor that's outside of the US. You have a vendor that's outside of your home country that you would like to use for production of something. Or you have an independent contractor that you hire to do something for your business. These are the types of things that I'm talking about. If you would even like to joint venture, let's say there's a production of a service or a good, and you want to bring on another company within another country, and you kind of want to joint venture and make sure that you guys can produce this thing together. That brings on a lot of negotiation and terms that need to be put in that agreement as well. So if you're doing any of these things currently, I would strongly suggest that you have an international contract that's going to touch on some of the things that I'm going to talk about today, because it just makes it better for commerce, better for business. And, I always say all things lead to litigation. If you have to get down to the point where you have a dispute, you want to make sure that you are on point with your contract. I have a client who did an international contract with the US and another Caribbean country. And when they went to negotiate the contract, they scratched out a line within the contract and they added a few words because they were negotiating. And 3 years later, they're still in litigation for that one line that was written in. So it's like, you think that it doesn't make a difference. Let me scratch that out. Let me put that in. Let me change the terms. They're literally in litigation right now, 3 years down the road, for that one thing that was added into the contract. So that just goes to show, and I tell the client all the time, why didn't you consult me before you added it, before you signed the contract? Why didn't you just, ask me what I thought about it? Because I did the contract, but they added stuff afterwards. So, that just goes to show, you might not think that it's important, but you definitely have to take into consideration that you are not, if you are in the US right now, if you have a business within the US, you're not in the US anymore. You're dealing with completely different places. Did you have a question?
So, yeah. So then what becomes the issue, whether it was added before or after both parties signed?
It was what was added. So I wrote a contract that was reflective of what the professional relationship was going to be. Mm-hmm. So when the parties met, and they met off-site, so off of the US, they met in another country, and they negotiated another thing, and they added in another point that I did not discuss and I did not write. They hand wrote it, and they initialed it, and they signed the contract. And now they're under litigation for the thing that they wrote in. Not whether it was added before or after, but the content itself.
So then what is the issue if it was added and then both parties sign off on it?
The issue is that they should not have written in a part of the contract. Not that it was not, contractually binding, but they should have not written in parts of the contract, because they're doing it from a business point of view, which I understand. You're doing business, you want to get going and whatnot, but you do not understand. Most people do not understand the legal implications of what they think is something that they innocently wrote in. And lo and behold, when I saw it after the fact, I got really upset with the client. And I said, why did you do that? Because this now means this. Are you going to do this, this, this? Oh, we didn't really discuss that, or we didn't talk about that. So it's like, you want to make sure that you do not sacrifice, right, the legal implications and possible disputes just because you want to get those businesses going. That's why it's really, really important that you have these contracts together and that you really think about the implications, because again, we're dealing with two different legal systems. Now they're in court, the US company for the other country. Now you have to Zoom court, and you have to appear personally, and you have to do all these things because you didn't really set up your contract correctly, or you did, but you added things afterwards. So, that's just being tangential, but it just goes to show that you have long-standing implications. So if you have a contract that you're using right now for your business, and you're like, oh, this is fine. I use this here in the US. I use it for California. I use it for New York. It's okay. It really depends on what other country you're planning to engage with, because it's just not going to translate well. right? So you have to make sure that there's a lot of other things. So with that said, I want to get to some of the things that I want to highlight. And again, this is absolutely not a full list. These are just a few considerations that I want to bring to your attention, and also a few clauses that I thought needed to be really, really highlighted in international contracting. So the first thing, CISG. What on earth is CISG, you might be thinking? It is the United Nations Convention on Contracts for the International Sale of Goods. It's a mouthful, but it's what the UN got together, and they decided that they would have this CISG so that you can have something that regulates how international trade happens. So there is a standard out there. Like in the US, we have the UCC with Uniform Commercial Code, and we kind of have that for the sale of goods. Internationally, there's a CISG, and it's fantastic. If your country is a signatory to it, and you've ratified that treaty, and you've implemented it within your country, and you have it as a treaty within your country, and I believe when I looked it up, it was like 87 countries around the world are signatories to it. It already kind of gives you a playbook, as you know, if you will, of how you plan to regulate your business, because there's so much that goes into doing business that you want to make sure that you at least have something. Now, I have to say, the CISG is completely voluntary. So if you meet an international business person in another country, you have the ability to say whether or not you would like to use this as a framework, or some of it as a framework, partially or not at all. So you still have the ability as a business owner to make choices, but there are these resources that are out there to help you in forming your relationship with this person from another country, or this business from another country. So in the CISG, you will have certain ways of conducting business that are already within that convention that you can flip to and say, this is how we're planning to do this. This is how we're going to receive goods. This is what's going to be a rejection of goods. This is what's going to be this. So you can opt in to have those rules. The other thing that I definitely want to bring your attention to, if you're doing any sort of international business, especially if you're doing things where you have to transport, so logistics, you want to make sure that you use what's called the Inco Terms. I don't know if you've ever heard of Inco Terms. Many businesses have not, until I tell you what it is, and you're going to go, oh, okay. The International Chamber of Commerce, the ICC, publishes a list that's called Inco Terms, which is widely recognized. Many countries recognize it as the way that you do international logistics. So think about, you're selling bottles, or you're selling plastic bottles, or you're selling hats, or whatever it is that you're selling. You're going to want to make sure that when you're doing logistics, transportation, that you know who you're contracting with, that they automatically know who's paying for what, because there's a lot to pay for, right? Transportation, insurance, all of that stuff. You have to know who's paying for what. So the International Chamber of Commerce came up with these Incoterms, which are all these acronyms that can be used, so you automatically know, like, okay, we're on the same page. These Incoterms, again, can be negotiated with the buyer and the seller. It can absolutely be negotiated. But once you agree on it, then that is what it's going to be. So, for example, and then you tell me, because I know a lot of people ship to like the Caribbean and stuff like that. You'll see terms like CIF or FOB, and they will be on your transportation contracts. And if you've ever just flipped through and signed, that's fine. But I'm telling you, as a business person and someone who does this as a living, that is one of the first things that I look at. What are your Incoterms and what do they say? Why? Because every single Incoterm has a meaning to it, and it carries weight in terms of what it is that you're doing. So the most popular ones, you'll see transportation, shipping, FOB. You'll see just shipping, FOB. That means free or freight on board. What that means is that the transportation is transportation where the price of the goods includes the delivery to a port and the seller has to pay for it, right? And then the buyer pays for the rest. Because think about it in terms of transportation by air or sea, right? You're shipping to another country, it's either going to be by air or by sea. That's it. I'm trying to think. Yep, that's all it is. Or land, right? If you're driving, if you don't have to cross water, you can actually drive to another country. That's fine too. But we're thinking about shipping. Just very, very basic. If you're selling a product, who pays until it gets to the port? Who pays if it goes across the ocean? Who pays for it to get to the other port? Who pays until it gets to the warehouse? Those are all things that business people should be thinking about. They really should, because let's say you're crossing the ocean and the boat collapses. This is like legal law 101. The boat collapses and all your goods, I'm talking 20,000 bottles, are now at the bottom of the ocean. Who pays for that, right? So you have to make sure that you have insurance and all those things that come with having business to cover that loss, but who pays? So one of the things that the Incoterms does is assigns who pays for the risk. So with FOB, the buyer pays for the seller will pay until it goes to that first port. The buyer pays until it gets to the buyer's port, wherever in the world that is. Now, contrast that with CIF, which means cost, insurance, and freight. If you see shipping CIF, that's where that's where the seller will cover the cost, insurance, and the freight until it gets to the buyer. So with those terms can mean a lot, because again, I'm being very dramatic with what if the boat collapses, but what if your products are damaged, right? What if they get lost? That's a huge, if you're shipping, I said 20,000, but let's say you're doing 2 million of your product. That's a huge debt. That's a huge debt within your production. So you have to make sure that you have within that contract who is going to bear that risk. So Incoterms is another huge part of what the shipping is going to be, the transportation and logistics is going to be for your contract. If you've never paid attention to these before, this is where you definitely need to pay attention, because you're going to be able to have the insurances and stuff to match it. Now, a lot of people use freight forwarding companies, which is something that I recommend, and I do it even for my clients. Will say, I need to ship to Belize or whatever. And I say, okay, I'll find you a freight forwarding company. What that means is that company now does all the paperwork. They do your bill of lading for the shipment. They basically prepare the paperwork, the entry and the export paperwork as well. It makes your life easier. If you have a really, really good freight forwarding company, it just makes your life as a business person so much easier. So I would highly recommend that for a company who's shipping outside of the US or outside of wherever you are in the world to another country. It just makes it really, really a lot easier to be able to do that paperwork, because I can't imagine having to do that every single time you have to do a shipment, or just, either you have a freight forwarding company or you have a dedicated person doing all that paperwork in-house. But, I just send all my clients, when they contact me, hey, can you do all the exit paperwork, entry paperwork? I go, nope, but I will send you to a freight forwarding company who's actually going to do the logistics for you. And that usually works out really, really well. Again, you're still going to have to talk to that freight forwarding company about who pays where, who bears the risk of costs if something happens to those goods, because sometimes it can be really detrimental. And, you get sued and they needed it right away because they had a big event. And then, you have damages that just escalate. And it could be a problem. So you want to make sure definitely that you're covered.
So that would be the covered by the insurance, but somebody has to pay for the
insurance. Exactly. And the Incoterms, and there's a lot of them. I just pointed out 2 because those are the 2 that I see mostly on contracts for sales of goods. Those are the 2 I usually use. But there's so many different types. I can't remember how many different actual acronyms they are, but there's general ones for modes of transportation. There's a whole list and a category for just any type of transportation. And then there's specific ones that apply for transportation via the sea. So it's very, you pick what it is that you want and what works for the other party as well. And make sure that it's very, very, very clear in the contract in case something happens. Because again, we're just making sure that you're set up in case something does happen and you need to recover from it. So Incoterms, very, very, very important if you're doing deliveries or if you're doing any sort of sale of goods where you require logistics. So far we talked about the CISG, the ICC, which is Incoterms. I mean, all of these things, as you can tell already, these are not regular domestic contracts. I've never said those words for any of the contracts I've ever spoken about within the US right now, especially Florida, because these are things that are specific to international commerce. So as you can already tell just by those two things, we're outside the realm of just domestic contracts. And you will have yes, you'll have something very similar with FOB, CAF, and stuff like that, like within the US, but I'm speaking specifically Incoterms for when you do international commerce. The third one, definitely pay attention to this, and I definitely put this in a lot of my contracts. We have to address anti-corruption in other countries. We have to address it. Just to CYA, cover your, ASS, you want to make sure that you cover yourself and your business, because the last thing you want is for the Department of Justice to come investigate you for something that you didn't do, right? So we have to handle anti-corruption. The U.S. Foreign Corruption Practices Act, and I'm pretty sure you've heard about this too, because it's usually all over the Caribbean, FCPA. The U.S. Foreign Corruption Practices Act prohibits payments to any foreign officials or government officials for assisting you in your business. It also prohibits any bribery. It's an anti-bribery provision for U.S. citizens doing business abroad. Now, creative arguments, and I hear them all. In the last 7 years I've been practicing, you would not believe the things that people have asked me. But one of them is, well, I'm doing business in, name whatever country. I'm doing business there. So like, obviously the laws don't apply to me and the DOJ doesn't apply to me and, blah, 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 blah. And I go, nope, and let me stop you right there. The DOJ has that jurisdiction over you as a U.S. citizen. So that's how they reach out and they touch you, is because you are a U.S. citizen doing business in another country. So part of this anti-corruption, clause that we need to put into your contract is addressing that it's an anti-bribery clause for U.S. citizens doing business globally. So you can't, go ahead.
Can you clarify that? Because you say U.S. citizen, but does it apply to someone who has a green card?
You know what? That's a great question, because a lot of what I write talks about the U.S. citizenship, but I'm pretty sure as long as you're living here and you're a green card holder and you're living here and working here, probably raising a family here, doing business here, I would still recommend that you have something like this in your contract, just because you don't want that investigation. You don't want that probe into your business. You just want to make sure that you are covering yourself with the anti-corruption and anti-bribery. So again, the act prohibits payments to government officials to help you with your business or to get any businesses, And, I say that and I smile because it's all over the news everywhere, including in the US, right? I mean, there's everywhere. But that act is supposed to prevent you from doing any payments to retain businesses and for anti-bribery. So you can't bribe someone to be able to get you that contract in that country that's going to be $1 million contract. Like, you can't pay someone to get you that contract. Again, it's overseen by the U.S. Department of Justice. Mm-hmm. So, the DOJ can touch you because of the fact that you are a U.S. person, U.S. business. Now, I know they have other sort of requirements if you're a business versus an individual. And, I would probably write that in as we go along. And your contract should have some sort of term or condition that says, anti-corruption, and you mentioned the U.S. Foreign Corrupt Practices Act, and that you are prohibited, you and all your subcontractors, whoever works for you within the company, is prohibited from making those, what they call prohibited payments within the act, that you are not going to do that. You're going to abide by the act, And, you know, you have a right as a business owner that if you see anything that's happening that's untoward or going towards that, that you have a right to get out of the contract because of violations of this act. And, you know, you give yourself an out. You write that you're going to abide by it. You write that you're going to, like, you know, have an out for it because you do not want to have any sort of investigation within your business, because that could possibly ruin your business to have that done. So I always err on the side of caution, and I've said that so many times on this show because it's absolutely true. I err on the side of caution, and I would rather have that in and say, you know, this business is compliant with that you understand your rights, that, you know, neither you or your subcontractors or anyone working for you is going to engage in that. And that if you find out that that's happening, that you withdraw your contract or you stop doing business with this entity or whatever the case may be. But definitely important to include it. And I tend to include that in all my international contracts, just because most of them are U.S. companies going into other countries. And if it's a company that I'm representing, well, I mean, I practice in Florida and I'm licensed in Florida. So most of the international contracts I do are originating out of Florida to another country. So I definitely make sure that I put that in, because we're talking about a Florida business who's under the jurisdiction of the U.S., who's under the jurisdiction of the DOJ. So, you know, again, CYA, we want to make sure that we don't, we know that we are not engaging in anything like that. Not that I think my clients will ever tell me if they do, but I want to just make sure. And if they do, and I probably wouldn't represent them, that's for sure. And I've turned companies away before, and I've turned individuals away before that I wouldn't represent, because I just don't buy their story. But yeah, very, very important. So now we've pointed out 3 things that are just, you know, I've never mentioned on this show before because they are not necessarily needed in domestic contracts. But I would highly, highly recommend that you take a look at if you're doing international contracting.
I have a question.
Yes.
Should musicians implement these costs on their music production that are being shipped to international retail stores?
Yes, I would say yes with this. If you are having a distribution agreement, because I think that that's where this would fall under, or even a joint venture. So you make your music here, you have someone who's distributing in Jamaica to someone who's distributing in Belize, Guyana, wherever. You would want to have a distribution contract with that person that does address that. Because again, if you're shipping to Jamaica and all your CDs are lost, who's paying for that, right? Or if you're doing, what is my first thing that I talked about? You might not even need to do the CISG, but at least have some sort of, and I'll get into it later in the show, dispute resolution that you can do, where you pick a country and you figure out what's going to happen if push comes to shove. And, you know, I always think litigation in my mind. Yes, I think that you should have a transportation logistic clause in there if you are not using a freight forwarder, which you might not need to, because, you know, music and CDs, if you're literally sending CDs, I think that you should have some sort of distribution agreement in place to make sure that you cover that. Anti-corruption, absolutely. I wouldn't suggest for you that you leave that out, because when you're talking about government assistance to get something in there, it's not just government contracting for like construction or whatever, but you just don't want to, someone in the government and you're passing them a couple $1,000s. Well, I don't know what Jamaican currency, what the equivalent is, but you're passing them money to be able to, get into these, whatever the case may be. You just don't want to be associated with the fact that you're making these prohibited payments. Again, I'm using the words of the act to be able to get into places that you're not getting into. You may not have that applicability as much with the music industry, but you never know. And never say never. I always put it in as a fail-safe, because you never know. Maybe there's a national song competition in Jamaica, because we have a lot of song competitions in Belize, and the winner gets to be in Belize we have a carnival competition, and you have this whole national thing where whoever wins is like the carnival song of the year, and it's like a big deal in Belize. So let's say you flip a few thousands to make sure that you have that visibility. That could be a way that would be a prohibited payment, right? So I always have these in my contracts to make sure that you at least CYA. But that's a great question. That's a great question. Now, the other thing, because I'm thinking ahead for your listener, the other thing is, what if you don't create the CDs and ship them? What if you just send them the music digitally? Now, that would be an interesting question, right? So you send it to the other country, and they're in charge of getting that digital music, because you could email it or whatever, getting that to someone else. You might not necessarily need the Incoterms for that, because you're not technically shipping or using, you're not driving, you're not flying, you're not using it by the sea. So you might not necessarily have those considerations, but you will have the considerations of dispute resolution or commerce in any way possible, because it's still commerce, and you'll still have the anti-corruption and some of the other things that I'm going to talk about for the rest of the show. So yeah, even if it's just streaming and you're not physically sending anything and it's a product, because you're still selling a product, I would have this. I would have these in it. Okay. Listener, tell me if I answered it, but where you're okay with it. So let me get into it. That's a good question. So let me get into the other ones so you can have more of a meat of what I'm talking about. Currency and payment structures. This is a big, big deal, especially I've noticed with the Caribbean. You have to identify the currency in which you will be doing business. Big, big issue, because it's very different to tell me, to say 1,000 US dollars and then 1,000 Belize dollars or 1,000 Jamaican dollars or 1,000 whatever, right? So it's very, very different. So make sure it's a very small thing, but it's not that small when you think about it. Identify the currency that you're using. And I get into such a habit of putting USD in front of everything that I write in my contracts that even when it's domestic, I have USD and I have the amount just to make sure that it's United States dollar, that they know that they're talking about in terms of, payment, settlements or whatever. Make sure you specify currency, because if you're negotiating and you're like, whoa, I can't believe I can buy that for $1,000. Whose dollars are we talking about here? So make sure you specify currency, very important. Make sure you also specify payment system. For me, this is really topical, because as you know, as our Caribbean community knows, we've really been hit with this de-risking of our banks in our countries. So we've lost a lot of correspondent banking within our countries, and what happens? That makes the wire transfers even longer, sometimes impossible depending on where you are, because we just don't have any US banks to back that, to bounce that transaction off of as a correspondent bank. So if you're talking about a payment system, how much am I going to get paid for those, that original music that you sent me? How much am I going to get paid for it? What currency and what payment system? Are you going to wire me the money? Are you going to, send me a check? I don't know how long that would take. How are you getting me my payment? That would be the first thing that I would think about.
And I think that would go hand in hand with something that you spoke about on one of our previous episodes about making sure when you are expecting a payment, make it so easy to get your money. So yes. People aren't trying to figure out, well, I know I'm supposed to pay, but how do I do it?
Yep. It's so easy. Here's the credit. I've started doing credit card authorization and links now. I used to always have links, but then I've found out that my payment system that I use, one of my other attorney colleagues told me that the person that they provided legal services for then went ahead and disputed it with the credit card, and the credit card took back the payment, and she showed them the retainer agreement that says, look, you retain this law firm to help. And they said, no, we can't help you unless there's a credit card authorization form, even though there was a retainer agreement. I think that's crazy. So what have I started doing? Now you have to fill out a credit card authorization form for me too, even though I have the link, I have the retainer, the engagement agreements, I have all that. So now for me, it's like, here's credit card authorization form. I at least have your signature that you're allowing me to take this money. Even though you are going to enter the transaction yourself, at least I still have proof that you're allowing and authorizing that, that engagement. But that's very, very important, especially in international transactions, because as you know, the loss of the banks in Belize have caused wire transfers sometimes to take 3 weeks. 3 weeks to a month. I've heard my other colleagues say 3 weeks. That's really great. It takes us months. So it just depends on where you're sending your money to. Other countries might not have this issue, but we have this issue right now in the Caribbean. That's why the de-risking situation is something we're going to talk about in Caribbean American Legislative Week. That, you know, I'm going to bring Wesley on, and we're going to talk about that next month as well. But it becomes an issue. So you have to decide now, when I send you this email for my music that I want you to now produce and get into the radio stations, wherever, they're expecting payment. Okay, when is my payment going to come? Do I now realistically have to wait 3 weeks? You know, this is a consideration that your distributor might have. They might hold on to it and say, look, you know, we're not getting it out there until we see payment. And then you realistically have to have in your mind, well, payment is not instantaneous the way that it is necessarily here, where we can just Zelle something or Venmo it, or here it's so easy to get payments done. When you're doing international payments, if it's a country that's not as, I guess, developed, and I say that in quotes again, as the US, then you might not have the same ease of doing business. So it's really important that you understand the payment structure of the country that you're dealing with, the payment systems of the country that you're dealing with, and then also how, like, what is the mechanism for getting payment? Are they going to hold on to your music or your products or whatever before they get paid? Are they going to wait 3 weeks or 4 weeks? Or what if there's more of a delay? Then you have 2 months of waiting for something. You know, so just make sure that you have that already worked out. And like Lisa said, I talk about that a lot, because you don't want to delay in your payment. That's the one thing I know that business owners do not want. Is I've never met a business owner that says, yeah, I guess I can wait to get paid. No, everyone wants to make sure that they get paid. Mm-hmm. So you have to make sure that you pick something that's viable for your business. If the wire transfers are too long, then figure out, I don't know what else to say. Just, you know, you have to figure out a way to make your payments work better. Also, governing law, venue, and dispute. This is super, 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 super important. You will have to choose now what law governs your contract. Remember, we're talking about 2 different countries. When we had the governing law discussion before, Lisa, we talked about state to state, right? Florida and New York, or Florida and Kentucky. Who are you going to choose to have the governing law? Now it becomes even more complicated because we have people in different countries. So you have to negotiate where you want your governing law to be. Will it be in one of the countries of the parties? Will you pick a neutral country? You see people pick Switzerland all the time. We're just going to do arbitration in Switzerland. Oh. To me, that's really far. But, you know, that's one of those neutral countries, right? So you can pick a neutral third country, or you can pick the countries that you're in. And again, this is all going to be negotiated. You would have to make sure that you have that completely negotiated. Then you have to figure out what venue that's going to be. So where are you actually going to have this dispute take place, and the types of dispute resolution. So we always talk about you can do litigation or arbitration. You know, now it's a step up because you're doing international. So you have completely different forums that you're going to use. You're not going to go into state court. More than likely, you're not going to go into state court in Florida and say, I want to sue a country in Jamaica. I want to sue a company in Jamaica. It doesn't work that way. You have to go through completely different channels. You might have to do international arbitration, and there's lots of organizations that do that as well. It's a different ballgame. We're just not in the same ballgame. So it's very important that you have that negotiated and really, really, really clear in your contract as you move forward, because that is the thing that's going to make or break. Now, my personal suggestion, what I always tell my clients, I say, sue them where they have their assets. So for example, it might be so much easier to be able to sue someone, let's say Florida and Jamaica, right? You're a Florida company, they're a Jamaican company, you're doing business together. I would always say that it might be easier to sue in Florida because you get your judgments faster, and you now force that other party to actually come to Florida and present their case and be in court and all that. You're kind of forcing them post-COVID world, you know, maybe, you know, we're going to get back to being in front of the judge, that you would have to make sure that they come to Florida and that they do their case. Now, when you win in Florida, you have a Florida judgment. How are you going to get paid on your Florida judgment? You would have to then go to Jamaica and enforce it in a Jamaican court. So again, you will win in Florida, but you still have to go an extra step to go and try to get that judgment enforced in another country. Or your option could be, let's have our court, our dispute and everything in Jamaica. So once you win in Jamaica, you can automatically get that that judgment enforced. So those are the types of things that I go through with my clients when they're choosing what governing law and venue that they want, because it's the ease of doing business. If the company is in Jamaica and they're making millions and millions of dollars, I would say sue in Jamaica, because you can levy those assets. It won't take as long to be able to get, what you need. If they don't have that, I would say, okay, let's do Florida and we figure something out. But it's very specific to the transaction. And I have to say that over and over again, this is not a one size fits all thing at all. So it's very specific to the transaction. It's very specific to what you're buying and selling. And it's very specific to the companies themselves.
I have one more question.
Yes.
All right. It says, in the UK, any type of correspondence between a solicitor and a foreign resident working on a case, the client must sign a contract to pay for each email communication. Would this involve a charge between telecommunications exchanges? Do you know anything about that?
No, I'm not sure what the listener means. Maybe they can sort of clarify. What was the last part of that question again?
The client must sign a contract to pay for each email communication, I guess, between themselves and the solicitor in another country. So they're wondering if would this involve a charge between telecommunications exchange?
You know what, listener, I have to tap out on this one, because I'm not sure how the UK does their laws. I know, and again, I can only talk to what I know, right? So I know that in Florida, when you hire an attorney, you can retain that firm. It can be hourly. You can pay per communication, meaning that you put money in a pot for communication and, mail and postage and all these other things that you can pay for. And they sort of they chip away at it for billing purposes. Now, I'm not sure that's what you mean in the UK, that they do that as well. And I think that would probably be a discussion with that individual and their own solicitor to see how they work things out. And, again, you have a right to negotiate that too. Mm-hmm. If you hear that someone is, and even here, again, I have to go, talk about what I know. Even here, I'll have clients say, do you charge every time you talk to me on the phone? Because some lawyers do. And, good for them. They do that. I just can't be bothered with the administrative work in figuring that out. So I don't, because I charge flat fees for what I do. So maybe it's a case of that, listener, where you have a solicitor, which is an attorney there, who does charge per communication. And, that's up to your engagement with that solicitor. Okay. And, that's all I can say about that. If you have a more specific question, I can try to find you someone who actually works in the UK that would be able to answer that question. But I think that would be a discussion between the business owner and their solicitor to be able to figure out that engagement, if I'm understanding your question correctly. Okay. If you want to re-ask clarify and re-ask, please go ahead and do so before we're done with the show. Or if not, email at info@mybshow.com and we can make sure that we get you a more direct answer, because I'm not entirely sure what you're asking, but I think that you're asking about the relationship between the business owner and their personal solicitor, and every time that solicitor has to do a correspondence for the business owner. Do you get that same impression, Lisa, if that's what they're asking?
Yeah, it seems that way, yes.
Yeah. So I think that would be more of a discussion between you and, the business owner and their solicitor to see what their terms are for their engagement. Because again, every firm, every attorney is going to be different. It's just however they decide to run their business.
Okay.
But good question. Thank you for asking. heightened importance, very heightened importance for contracts. Now, these are things that you may have in your domestic contracts as it is, but I want to say that this receives some heightened importance when you do international contracts, because it becomes important because of the distance, the different countries, cultures, and what have you. So notices. Usually you'll see in contracts, in case there is a dispute or in case you want to have official communication, these people are going to have notices. And it's usually one party, the other party, or third party, whatever. But they're going to have the person to contact, they're going to have an email, they're going to have a mailing address or whatever for you to be able to contact a person in case you need an official notice. That becomes really important for international contracting, because if you are talking to, let's say, a distributor, or you're talking to a vendor, or you're talking to, independent contractor company, the person that you're talking to might not be the person who needs to be on these official correspondences, right? So like a legal team, or someone who's the attorney for the overseas company, or someone who is a CEO of the overseas company, you have to make sure that you have that point of contact and you have the right parties for notices. Because if you spend the money to do service of process internationally, which can be very expensive, you want to make sure that you get the right person, so and that you have that legally binding service of process so you can continue with a lawsuit, because you need service before you do a lawsuit. So you want to make sure that your notices are on point and directed at the right parties. And since we're talking about parties, we want to make sure that you have the correct parties after doing due diligence as well. So now we're talking about doing overseas businesses. You want to make sure that the business that's within that other country, that you have the full legal name, you have their address, and it's not, for example, like, some of these businesses will have subsidiaries in other countries, or they'll have sister businesses in other countries, or maybe be a subsidiary of a US company. You have to make sure that the party that you are contracting with is the party that you're going to be doing this business with. And it's very, very important, because a lot of times you have foreign businesses that have other relationships with other businesses around the world. You have to make sure that you do your due diligence and you pinpoint that party that's going to be the name on that contract, because now you're entering into a contract with specifically them. Intellectual property, huge issue. Our listener who sent the question about the music, intellectual property has to be discussed in your distribution contract. It has to be discussed. I can't even say it anymore. Intellectual property, if you created this music, if you created a copyright, or you created a logo, or you created something that holds intellectual property and you own it, you want to make sure that that intellectual property right goes with the parties that created it, right? Unless you're assigning it. So if you send it, for example, to a distributor to be able to touch it up a little bit, or send it to someone who's going to touch it up a little bit and then send it out, you have to make sure that you specifically say in your contract who now holds the intellectual property rights to that product. Because whoever has that intellectual property right has rights over how it's licensed, it has rights over how it's sold, it gives you rights. So one of the, I guess, domestic contracts I've seen for a young artist, where I've reviewed for her and literally told her not to sign it, is where she was literally going to be assigning her intellectual property rights to her music to this person who was going to produce it and distribute it for her. And I pinpointed that to her mother. This is how young this young lady was. I was on the phone with her and her mother, and I said, don't sign this, because you're giving up your rights to this music. And what are you getting in return? Now, if you're selling it to a producer and you're getting, what you deserve for it, that's fine. But this young lady, I think that the producer was really taking advantage of her naivety, and she wasn't getting what she deserved for the music that she did. So same thing, when you're doing international contracting, it becomes even worse now, because now you're in another country that's harder to enforce. If you're in the US, cease and desist letter, we can rock and roll with this all day long. If you're in a different country that might not have as stringent IP laws, then, you're sort of left in the wind. So you want to make sure that you absolutely address intellectual property when you're having your international contracts, not just for music industries, but like trademarks, logos, things that you have on your products, images that you might have on your products. It's yours and you should keep it unless you decide to license it, unless you decide to sell it. But it's your decision as the business owner to have that. And wow, we're right at the end. The last thing I want to say is termination. Termination becomes really important when you're doing international contracting because, again, it's not like you're in the same space. And the country you're dealing with may have different laws as it applies to termination. So even within the US, some states talk about termination for cause, without cause. Some is needed, some is not needed. Certain Caribbean countries I've dealt with, termination had to be for cause, which is very different from the US. So just make sure that you are aware of what you're contracted into and don't make any assumptions on that termination front. And those are some of the points that I had highlighted for just a heightened level of instruction, heightened importance when you're dealing with international contracts, the notices, the parties, the intellectual property rights, and the termination. And of course, there's many, many others that, I only have an hour-long show, but there are many, many other clauses that I would say is really, really important to have in your international contracts. And I'm going to do my bottom line for the show since we're coming up on 5 o'clock, is that you really need to do your research within not necessarily laws of that country, but do your research in terms of how to engage with another culture in another country, because it makes a huge difference. And, if you don't know, you can always hire a professional to do it, because doing business in a global community is very, very different from doing domestically. You might think, well, it's only an hour flight away. It's not a big deal or whatever the case may be. But it really adds, it's like a heightened level to me. When I see someone doing international business, you're definitely taking a step up with your business. And as such, you should be taking into consideration more things. So with that, I'll say that, make sure that you do your research, because you have to be able to do the global commerce well. It can make or break your business. Make sure you do your due diligence. Make sure that you hire professionals if you're not too sure what you should be doing. And really, really focus on that expansion of your business or that other part of your business, because success comes when you're minding your business.
Thank you. Thank you, Rishma.
You're so welcome. Have a good day, guys. And remember, send questions to info@mybshow.com, and we can either have a part 2 of this, or with the listener with the UK question, definitely send me an email. I'll see how I can help you. The content on Minding Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.